Welcome, everyone. I'm Amanda Townley, Executive Director of the National Center for Science Education. We are thrilled to have you join us tonight for our Scope Centennial webinar series, where we will continue to explore the legacy and ongoing relevance of the 1925 Scopes monkey trial. This webinar is the first of three sessions that will address the past, present, and future in this 100th year since the first battle over evolution education in the United States. Today's session, The Trial of the Century, Scopes at 100, features our organization's founding executive director and dear friend, Dr. Eugenie Scott. Now, before we get started, I have a few quick notes. So remember, this is just one event in our year-long Scope Centennial celebration. And a number of us, in fact, were with Jeannie at Vanderbilt University in Nashville and in Dayton, Tennessee, just a few weeks ago as part of an NCSE co-sponsored Scope Centennial Symposium. So be sure to check out the remaining two webinars in this series and take a moment to register at ncsc.ngo/Scopes Centennial Celebration. We'll provide that link again so you don't miss them. But there's good news. If you do happen to miss a session, or you just want to revisit one of these incredible talks, each one of these three webinars will be available at the same page at a later time. If you'd like for us to continue to make opportunities like this possible, I ask that you please consider making a donation to NCSE. Your support truly makes a difference. There will be a Q&A at the end of today's talk, so please feel free to type your questions into the Q&A box at any time. We'll make sure to pass them along to Jenny as time allows. So thank you again for joining us, and it's time to get started with our dear friend and the woman who started this all for us, Dr. Jeannie Scott.
Hello, everybody. I'm trusting you can see my slides. Amanda, nod if that is the case. If you know, yay, the system works. What can I ask? I love talking about the Scopes trial. There are so many zany things that happen. It's just such a ripping good story. But also, I would like to think that it is relevant to us today, and maybe I can convince you of that. So let's just get into it. Or not. Now, most of you have heard the story of the Scopes trial in Dayton, Tennessee, where a brave young teacher, John T. Scopes, was tried here at the Ray County Courthouse for defying a law against the teaching of evolution. You probably know how, at the behest of local religious leaders, he was hauled from his classroom and thrown in jail, there to stay until the trial, and how the trial was a titanic battle between fundamentalism and the inevitable march of science. Ultimately, Scopes was found guilty, and he and his fiancée, the daughter of a fire and brimstone preacher, left town to start a new life. And all this happened 100 years ago in 1925. Oh, wait, that isn't the Scopes trial. That's the 1955 play Inherit the Wind. In 1960, Spencer Tracy and Frederick March, shown here, starred in the most famous movie version, and it has been remade for television 3 times. It is a terrific play. I've seen it, I don't know, maybe 4 or 5 times. It's just great. And the Tracy March movie is always on anybody's 100 best movies list. But it isn't the Scopes trial. For starters, writing in 1955, the authors of the play intended it to be a metaphor for McCarthyism. They were opposing the government clamping down on free speech. Quote, "We use the teaching of evolution as a parable," Lawrence told the newspaper in 1996, "a metaphor for any kind of mind control. It's not about science versus religion. It's about the right to think." Well, they did, after all, use a biblical phrase for the title, the Proverbs 11:29, "He that troubleth his own house shall inherit the wind." And although a lot of the play and movies concerned freedom of thought, the metaphor of science and religion also communicates directly, in addition to its metaphorical function. Furthermore, Scopes didn't have a girlfriend at the time, and there was no fire and brimstone preacher trying to get him jailed. Scopes, in fact, never spent a day in jail in his life, although he was indeed fined $100, which he didn't have to pay. And there are a number of other differences that you'll probably notice. My conclusion is that, however good as the play and movies were, the actual Scopes trial is more dramatic and really more interesting. It was indeed the trial of the century. So, where did we get here? What led up to the Scopes trial? In March of 1925, the Tennessee legislature passed the Butler Act, which forbade the teaching of any doctrine that, quote, denies the story of the divine creation of man as taught in the Bible, and to teach instead that man has descended from a lower order of animals. Well, what led up to this anti-evolution attitude? Well, for starters, there were two major social currents, fundamentalist religion and a fundamental misunderstanding of evolution. Fundamentalism isn't very old as religious movements go. It was inspired by the commissioning and distribution of a series of 12 pamphlets called The Fundamentals, meaning the fundamentals of Christianity, from 1910 to 1915, so pretty recently. Two wealthy businessmen funded the distribution of 250,000 sets of the booklets to Protestant ministers, missionaries, and theologians around the country, which very quickly spread this movement. Now, fundamentalism didn't call for the Bible to be interpreted literally, but that it was inerrant, which is a different theological concept. However, inerrancy slid over into biblical literalism fairly quickly in most people's minds, and most people who identified as fundamentalists interpreted the Bible literally. Well, evolution is in fact not compatible with the literal interpretation of Genesis, so it didn't take long before there was opposition to evolution from this segment of the Protestant religious community. But even outside of the fundamentalist community, many socially progressive thinkers associated evolution, especially natural selection, with the evils of social Darwinism. Now, social Darwinism is a misinterpretation of Darwinian natural selection, which was promoted by Herbert Spencer. Sweatshops, child labor, exploitation of workers, all of these and more were justified by laissez-faire capitalists such as Andrew Carnegie as being natural and therefore being good and therefore being okay to inflict upon your workers. So, of course, people who cared about the welfare of their fellow human beings opposed evolution along with capitalism. As if the evils of unfettered capitalism weren't bad enough, evolution was also associated with a truly evil idea, eugenics. The father of eugenics was Darwin's cousin, Francis Galton, who was a really interesting guy, by the way. He read on the origin of species and was inspired to develop ideas about the betterment of human species through selective breeding of the more fit, what came to be called eugenics. Now, eugenics was also conflated with evolution and natural selection, so that was another reason to oppose evolution. A fourth reason was the appalling devastation and carnage of World War I, the Great War. World War I seemed to many, whether they were educated or not, religious or not, a symbol of civilization gone wrong. Before World War I, the Germans had been considered the epitome of science, of industrialism, even culture and modernism. Yet they were accused of the most appalling atrocities. But whatever the Germans did, historians do not believe that they were inspired by evolution or natural selection. The Great War, though, created a lot of cultural angst. So there were plenty of reasons to oppose teaching evolution, religious ones certainly, but also secular ideas, some of them confusing the science of evolution with misinterpretations like social Darwinism or eugenics, or not entirely accurate history about World War I. So the anti-evolution movement got going largely after the publication of the Fundamentals and after World War I. The leader of this anti-evolution movement was a famous progressive politician, William Jennings Bryan. Now, Bryan gets a bad rap these days, and he really doesn't deserve all of it. An historian commented that a player gets judged by his last innings, so Bryan is judged by the Scopes trial. But his life was so much more. Bryan was one of the most famous and beloved politicians of the day. He was tall, he was handsome. Now look at this guy. We only see the old Bryan. We don't see this guy. He was blessed with incredible oratory skills. He could bring an audience to their feet or bring them to tears either way. The great commoner had served as a congressman and was the youngest man to run for president at age 36. He also served in President Wilson's cabinet as Secretary of State, so he was quite prominent, quite well known to the public. He was called the Great Commoner because of his faith in ordinary people. He stood for policies that are taken for granted these days, but which were pretty radical during the Gilded Age. For example, women should have the vote. What a thought. Workers should not have to work more than an 8-hour day without overtime. Children should be in school and not working in factories, much less slaughterhouses in Oklahoma. Imperialism is bad. We should have pure food and drug laws. Corporations should not finance campaigns. Too bad that one didn't stick around. Senators should be elected by popular vote. Government should serve the people, not the bankers and industrialists. Too bad that one didn't stick around either. And many other progressive policies, many of which Bryan helped Wilson get through Congress. But lest one get too warm and fuzzy about Bryan, though, he was also a eugenicist and believed in the superiority of the white race. When he left politics late in life, he devoted himself to campaigning for prohibition, promoting Christianity, and opposing evolution. The last innings. The historian Ed Larson describes him as promoting left-wing politics and right-wing religion. He actually was not as religiously conservative as Matthew Harrison Brady in Inherit the Wind. He accepted that the earth was old, for example. He was actually a day-age creationist. And although he did believe that God created humans specially, he was open to the idea that other species had evolved. When it came to evolution, yeah, Bryan didn't like it because it didn't reflect the Bible, but he was primarily a social gospel Christian, and mostly he didn't like evolution because of his association of evolution with social Darwinist views of the robber barons and others. The Butler Act wasn't the first anti-evolution measure. After Bryan gave an invited speech to the Kentucky legislature, the first anti-evolution bill was introduced in January of 1922 and failed by only one vote in Kentucky. Oklahoma passed the first anti-evolution bill in March 23, which banned textbooks from covering evolution. And later that spring, in May, also after some lobbying by Bryan, Florida passed a resolution discouraging teachers from teaching evolution. And even here in California, the State Board of Education warned teachers to teach evolution as a theory only. So the Butler Act reflected its times. When it was passed, fundamentalists rejoiced. The more secular community, less so. The American Civil Liberties Union had been founded only 5 years previously in 1920, and this issue was perfect for it. To the ACLU, the Butler Act was an attack upon free speech and freedom of thought, but to fight it, they needed a plaintiff. The ACLU took out advertising in a Chattanooga newspaper, promising they would defend any teacher willing to bring a test case against the Butler Act. Enter the smallish town of Dayton, about 800 people, about midway between Knoxville and Chattanooga. It was a relatively new town and the county seat of Ray County, but it didn't have a strong economic base. A lot of mines recently had closed in the area, and it was losing its population base. People were moving away. A transplanted New Yorker living in Dayton, an engineer for one of the mining companies, businessman George Rapelier, read the ACLU advertisement in the Chattanooga Times and came up with the idea that if Dayton could find a plaintiff to challenge the Butler Act, they'd get a lot of publicity. Maybe produce a Chautauqua-like atmosphere for the summer and bring commerce to the region. Little did he know. Rapelier convinced some others and got general agreement that this would be a good publicity stunt. Meeting at Robinson's drugstore, the conspirators mused over who they could get to be the plaintiff. Had anyone actually taught evolution at the one high school in town? There weren't a lot of choices because there weren't a lot of teachers. They soon settled on an amiable 24-year-old science and math teacher and part-time football coach, John Scopes. They sent a runner to get him from the tennis court to meet them at Robinson's drugstore and asked him, "How do you feel about the Butler Act, John?" Well, Scopes had gone to the University of Kentucky, and he really admired the faculty and the president of the university when they pushed back against the Kentucky Anti-Evolution Act. And so he was absolutely on board with opposing the law. In fact, he spoke about that many times during his life, that he thought the Butler Act was a terrible idea. Had he actually broken the law by teaching evolution? Well, he had substituted for the biology teacher and had used the state approved biology textbook for review, and it included evolution. So, arguably, he had taught evolution, or was at least evolution adjacent. It was a most cordial arrest and arraignment. This picture is a reenactment of the meeting at Robinson's drugstores with attorney Herbert Hicks sitting next to Scopes. Don't you love all the hats? I mean, these people always, the men always wore hats indoors. It was great. George Rapelier and attorney Sue Hicks were in the top row. Prosecuting Sue Hicks, in fact, was a friend of Scopes. They used to double date. And since they plausibly could claim Scopes taught evolution and thus broke the law, Hicks cheerfully agreed to prosecute him. The point was to challenge the law and get it overturned as unconstitutional infringement on free speech and freedom of conscience. They thought, that they were united in that idea, and if it got Dayton some publicity, that was fine too. So Rapelier got the justice of the peace to swear out a warrant for Scopes' arrest, gave it to a constable to serve Scopes, and Scopes was officially arrested and arraigned for violating the law. And then he went back to his tennis game. Rapelier then called the ACLU and said, "Good news, we got a plaintiff." But of course, Rapelier wasn't the only one to see the ACLU ad, and to forestall others in Tennessee from trying to mount a trial, the Dayton crew convinced the Ray County grand jury to meet 3 months early to indict Scopes. So Scopes was indicted twice, and the publicity stunt was well on its way. Now, here I must digress to tell you that there is a quite plausible possibility that Sue Hicks, who was named for his mother, who died a short time after childbirth, was the inspiration for the song A Boy Named Sue, made famous by Johnny Cash. Shel Silverstein, the author of the poem, had heard of Sue Hicks in the late 1960s and had given the poem to Cash, who turned it into a song. Johnny Cash sent Sue Hicks, who by the 1960s was a Tennessee judge, 2 autographed albums, writing, "To Sue, how do you do?" Hicks had a sense of humor, thought it was pretty funny, and must have been a good guy in that regard. But back to the Scopes trial. The county prosecutor, Herbert Hicks, and his brother Sue began to assemble a legal team. They added Walter White, who was a conservative Republican, and the superintendent of schools, not a lawyer, but a man about town and well respected. There were complaints from some of the locals that the Hicks brothers wouldn't be tough enough, so they needed a mean guy like Walter White. And the chief prosecutor would be Tom Stewart as Attorney General of the district. But things rapidly changed when the great commoner volunteered to lead the prosecution. The ACLU is also setting up its defense team. Arthur Garfield Hayes was a competent lawyer for the ACLU. Obviously, he would be involved. John Randolph Neal was a quirky Tennessee lawyer who volunteered, or perhaps I should say pushed himself on the team, kind of demanding that they use him. And there were a few others who were cycled in and out. But these were largely eclipsed by the announcement that since Bryan was going to be the star of the prosecution team, the mighty Clarence Darrow would be there for the defense. Clarence Darrow was a Chicago attorney who had worked for populist causes like trade unions, worker rights, women's suffrage, economic reform, civil liberties, freedom of thought. Like Bryan, he was a progressive. In fact, he and Bryan had worked together in Democratic politics when both were younger, but they were never really close. Bryan was just too religious for the likes of the self-described agnostic Darrow. And obviously, Bryan wasn't crazy about hanging out with Darrow either, as the village atheist, basically. Now, Darrow was thought to be one of, if not the best, trial attorneys of the 20th century. He brought in Dudley Field Malone. Malone was a lefty New York political reformer. He was another Democrat, another supporter of women's suffrage, and an anti-war activist who was a highly competent lawyer. But he was a divorced Catholic and a divorce lawyer, and that didn't sit terribly well with the good folks of Tennessee. Neither did the agnostic anti-religious Darrow. Malone overcame his shortcomings in Tennessee by giving one of the most powerful speeches of the entire trial on the topic of academic freedom. By the way, Malone is almost always pictured in a full suit and tie, even when the other lawyers were given permission to dress more informally. It was hotter in blue blazes in Tennessee in mid-July. We know, we were there. It was hotter than blue blazes last month. Before Dudley Field Malone gave his big speech, he very carefully took off his jacket, folded it up, and laid it neatly on the table next to him, and immediately got everybody's attention. He's taking off his coat. The guy knew how to work a room. What can we say? And the speech was a real barn burner. It really brought down the house. Everybody loved it. The defense didn't want Darrow, and the prosecution didn't want Bryan. Both sides feared that these national figures would hijack the case to support their own causes. The ACLU wanted a narrow trial about whether a law that restricted an academic subject for religious reasons was legal. Now, narrowly interpreted, the Butler Act merely forbade a teacher from teaching a view that denies the story stated in the Bible. So, what is the story stated in the Bible? Well, there's more than one. Who is to say that what Scopes taught contradicted the Bible? And further, because evolution was good science, not teaching it would be irrational, and requiring someone to behave irrationally violates due process. Hayes contended that it is no more reasonable for Scopes to be told to not teach evolution than it would be for the state to require him to teach geocentrism. The due process argument is related to an academic freedom argument. Scopes had academic freedom to teach state-of-the-art scholarship, in this case, evolution. Further, the defense argued that the Butler Act was unconstitutional because it bent instruction to fit the Bible, which made it a freedom of religion issue. Their goal was to get the law struck down. That was what they wanted to have happen. Darrow didn't disagree, but village atheist that he was, he couched the argument in terms of freedom of conscience about religion. People on both sides agreed that Darrow's opening statement was a masterpiece. He argued that making the Bible the arbiter of what is true and can be taught is not only an unconstitutional establishment of one religious view after another, but it's a terrible assault on freedom of thought and conscience. We are marching backwards to the glorious age of the 16th century, when bigots lighted faggots to burn men who dared to bring any intelligence and enlightenment and culture to the human mind. He could really write us the speech, too. The prosecution lawyers also wanted a narrow case. Stewart and Bryan would argue that the state had the authority to tell teachers what to do because the state paid for education. Their position was that the case against Scopes didn't have anything to do with religion. Of course, Bryan would throw that narrow focus right out the window because his issue was religion, and he wanted to go beyond the "he who pays the piper calls the tune" argument. To show that the law was backwards and irrational, the defense planned to have a series of noted scientists and theologians to defend evolution and argue that there was no necessary conflict between evolution and Christianity. The prosecution also wanted to call expert witnesses to claim that evolution was scientific claptrap, but this was a problem. First, there wasn't a very large pool of people trained in science who rejected evolution. And second, the few who did weren't available or weren't sufficiently anti-evolutionary for Bryan's purposes. The most famous anti-evolutionist of the day was Seventh-day Adventist George McCready Price, who founded Creation Science. More on that later, NCSE folks. So since they couldn't counter the defense witnesses with witnesses of their own, the prosecution sought to get them struck. They managed to persuade the judge to stick with the narrower legal issues and forego testimony on evolution's scientific bona fides. The judge also wanted to have as quick and tidy a trial as possible. The scientific witnesses dictated their testimonies and left them with the court and went home. Now, another little quirky Scopes story, of which there are many. The defense operated out of this old mining company headquarters on the outskirts of Dayton, which had been abandoned after the mine closed, and Rapelier renovated it. Lawyers, scientific and religious expert witnesses, all were housed here during the trial. Now, the night before the witnesses were expecting to testify, there was an absolute gully washer, a thunderstorm that shook the house, shook Dayton, pitchforks and hammer handles, everything fell out of the sky. It was a doozy. All night long, the expert witnesses were hoping and probably praying that a house full of evolution witnesses would not be hit by lightning the day before their testimony. But because expert witnesses were ruled out, one of the most dramatic events of this or any other trial occurred, and it is even central to Inherit the Wind. Darrow couldn't bring in scientific witnesses, so he proposed to interview an expert on religion, William Jennings Bryan. It was an audacious move that the prosecution lawyers vigorously pressed. No, we don't want Bryan to testify. Absolutely not. Stop, stop, stop. Bryan, of course, was a man of not inconsiderable ego, and he was dying to be able to question Darrow as well. So he agreed to be questioned by Darrow if later on he could question Darrow. And both of these lawyers wanted to do it, so the judge said okay. The judge and probably everybody else in that room were just dying to see these guys go out one after another anyway. Now, my husband is a lawyer. My daughter is a lawyer. There is a legal technical term for this, and that is, this is bonkers. Can you imagine anything nuttier than the prosecution lawyer and the defense lawyer questioning each other on the stand? This just doesn't happen. This is just so nuts. Well, but it was going to happen. Because it was such a hot day and there were so many people in the courtroom, the judge moved the trial outside under the shade of trees, which meant that a huge audience of people, literally thousands of people, witnessed this extraordinary event. And Bryan is sitting, Darrow is standing, and you can see some of the commotion around them. The defense's position was that Scopes and all teachers should have freedom to teach accepted science and not be fettered by religious dogmatism. Darrow's goal was to make Bryan look out of touch and even foolish. Now, whether he succeeded or not depends on press coverage and who you read. But Darrow asked Bryan about a number of Bible stories. For example, the story of Joshua and the Battle of Jericho. Now, the Bible says that God lengthened the day so that Joshua could win the battle by stopping the sun. You can only lengthen the day by stopping the sun in a geocentric universe, which obviously Bryan was not going to support. So Bryan prevaricated, wiggled around a bit, and Darrow followed it up by asking, well, perhaps God stopped the Earth. Now, of course, this would get Bryan in trouble with physics and geology, in addition to astronomy, because everything on the planet would fly eastward at about 1,000 miles per hour. So Bryan was going to lose no matter what he did. And questioning went on like this for a while about the age of the earth, the literal interpretation of the days of creation, the flood of Noah, where did Cain and Abel get their wives, and so on and so on. From the audience standpoint, Darrow trapped Bryan into admitting that the Bible had to be interpreted and couldn't be taken literally. This generated gasps from the audience. Bryan was an educated man. He didn't want to get caught, or get the state of Tennessee caught, denying modern science. But of course, a biblical literalist interpretation of Genesis does just that. So Bryan did not come off very well in this exchange, which newspapers reported all over the country. However, this most famous element of the trial was held without the jury being present. It was during preliminary wrestling to see if expert witnesses could be called. The jury was called back in. They had missed most of the trial, and the defense essentially told them to convict Scopes. Their plan was to challenge the Butler Act on appeal. The jury convicted Scopes after a deliberation of 9 whole minutes. The judge assigned a penalty of $100, and the trial of the century was over. Darrow deliberately orchestrated the sequence to prevent Bryan from questioning him on the stand as he had questioned Bryan, and also from delivering a lengthy closing statement that was intended to double as a stump speech for his next religious campaign. There's more to be told about the Scopes trial, about the appeals to the case. The fine against Scopes was dismissed, but the Butler Act was upheld and stayed on the books until the 1970s. And interesting things happened to people after the trial, but there's only so much you can talk about. Let's move on to the significance of the trial. I think Scopes is a fun story, but it's worth learning about even beyond being a good story. Remember the old adage that history doesn't repeat itself, but it sometimes rhymes? First, it was indeed the trial of the century. It also has relevance for education, especially the teaching of evolution, because believe it or not, the battle isn't over. The position you took on the trial was largely determined by what tribe you identified with, modernist or fundamentalist. The reaction to Darwin's questioning of Bryan about the truth of the Bible wasn't an inherit the wind response. Bryan did not leave the stage weeping, so to speak. Secularists and religious moderates cheered Darrow, and fundamentalists were convinced that Bryan won. Tribalism concerning public affairs certainly is something we wrestle with today. Although in this talk, I'm just going to have to skip this for time purposes, but it is very relevant today. Finally, and remember, this is not an exhaustive list, the Scopes trial led directly to the growth of Christian fundamentalism as a political force in the late 20th and early 21st centuries. I'm also going to shortchange this topic, but tune in 2 weeks from now to hear Adam Latz speak in the same NCSE series. He literally wrote the book on this subject and knows much more about it than I do, and it'll be a really interesting talk. So, why do I say that Scopes was the trial of the century? Well, for starters, as Ed Larson comments, it's the best known misdemeanor trial in America. The 20th century had its share of big trials: Sacco and Vanzetti, Leopold and Loeb, Lindbergh baby trials, Nuremberg trials, Sam Shepard, O.J. Simpson, the Manson family murders. These were all big deals and trials that the public attended to with considerable interest. But it was Scopes that set the template for trial coverage. For starters, consider communications. The Scopes trial was the first trial ever broadcast on that new medium, radio. Radio was the hot new technology of the time, and radios were slowly becoming common household items. Chicago radio station WGN had a series of microphones set up around the courtroom, these big guys here. So all the speakers could be heard. Unfortunately, there was no ability in 1925 to record the proceedings, but a huge number of Americans listened live. Live coverage of a trial set a standard for future press coverage and sensationalism. Thousands of miles of telegraph and telephone lines were strung from Chattanooga to Dayton, so the estimated 200 reporters could get out their stories. 65 telegraph operators wired stories back to the East Coast newspapers and to papers around the world. The civic boosters meeting in Robinson's drugstore had wanted publicity and to bring business to Dayton, but they envisioned an intellectual, Chautauqua-like experience. People would visit Dayton. People would visit Dayton, excuse me, attend talks and lectures, and while they were there, boost the economy of the town. But what they really wanted was they did want an intellectual experience. What they got was a sideshow. The circus atmosphere was obvious from the first day. Street preachers and Bible sellers lined the downtown. Prayer meetings and revivals were organized. Hucksters and salespeople of all kinds flocked to Dayton. It became a huge media, political, and cultural event with even a trained chimp. Among the estimated 200 reporters was H.L. Mencken. Mencken was a complex person, a political progressive, but also something of a social Darwinist. He was quite harsh on Southerners, whom we referred to as the bourgeoisie, and that was one of the kinder epithets. He was not alone in his mockery of rural Southerners, which tended to shape the image of the Scopes trial more along the lines of Inherit the Wind. The national press shaped the story, concentrating on the most sensational elements, again, establishing the template for splashy crime reporting. There were lots of opportunities for press hyperbole, one being celebrity. Bryan and Darrow were two of the most famous people of their time. It's no wonder that people listened to the radio or snapped up newspapers to read about the exchanges as soon as they were published. You can see why the Scopes trial was such a huge news story. It had strong, contrasting characters, and it dealt with serious social, political, and cultural issues. Bryan's big issue: what is the role of the state versus academic freedom in education? Can science be balanced with religion? What about fissures within religion about creation and evolution? So, this is the legacy of Scopes and the coverage of future crime trials, all of which I assure you will also be called the trial of the century. New media provides opportunity to reach a wider and wider audience in different ways. During Scopes, it was radio and newspaper reporters. Later trials have a different media configuration. The O.J. Simpson trial was carried live on television. Another example. Celebrity brings an irresistible dimension to crime trial coverage. Issues important to society are being raised. With the O.J. Simpson trial, it was issues of race and justice and justice the justice system and race. These factors increase the popularity of the event and thus the competition among the press to shape the story, with the prevailing story not always being the most accurate. My prediction is that the next trial of the century will feature as the prime medium not radio or television, but the much more diverse universe of the internet, especially social media. Already, a large percentage of people report that their primary source of news is social media, and this tendency is especially strong in younger people. The amateur world of podcasters, TikTokers, YouTubers, and other influencers, almost entirely untrained in actual reporting, but having nonetheless acquired a probably undeserved reputation of independence and trustworthiness, is being turned to for factual knowledge. And the results are going to be interesting, as in the old Chinese curse, that is. Stay tuned. Let me talk a bit about the relevance of the Scopes trial to education, especially the present-day teaching of evolution. In his effort to ban evolution, Bryan made 3 points. He attacked the science of evolution. He claimed evolution was incompatible with religion, and also, the pillar of the prosecution's theory of the case, citizens rather than experts should determine what children should learn. And, surprise, the anti-evolution campaign didn't stop with Scopes. These positions have also been taken by anti-evolutionists since Scopes. So let's take a look at the history of anti-evolution since 1925. For years, NCSE has used variants of this useful summary to communicate the history of the creation and evolution controversy. The Scopes era was the heyday of efforts to ban the teaching of evolution, and the effort neither began nor ended with Scopes. Dozens of anti-evolution measures were introduced in states after the Scopes trial, and Mississippi and Arkansas passed anti-evolution laws. More important than the laws, however, was the fact that textbooks quietly began dropping evolution from their coverage of biology. By 1930, evolution was scarce in high school biology books and slipped out of the curriculum and didn't return for decades. After Sputnik shocked the U.S. into realizing that it had to invest in scientific research and also science education, the National Science Foundation commissioned science textbooks that were written by master teachers and professional scientists instead of textbook publishers. So obviously, they included evolution. Commercial textbook publishers started including evolution as well, and evolution re-entered the high school curriculum. Arkansas still had an anti-evolution on its bill, on its measure, on its law, among its laws. Biology teacher Susan Epperson was chosen by the Arkansas branch of the NEA to take care of this housekeeping lawsuit. I mean, look, it's 1960, right? 1920 era's law banning the teaching of evolution, that's as out of date as flappers. Well, little did Susan know that the state judge would uphold the law and that it would be appealed all the way to the Supreme Court as Epperson versus Arkansas. Susan Epperson actually met John Scopes, who was 68, during the trial. In 2018, we held a 50th anniversary celebration of Epperson versus Arkansas with John and Susan Epperson. And if you look over my left ear, you will see Ken Miller, president of NCSE, who also attended the anniversary celebration. So what do anti-evolutionists do when it isn't possible to ban evolution? They created creation science. This brings us to the second of the broad historical periods of anti-evolutionism, balancing evolution. And by the way, these dates are only approximate, and the various periods, as it were, are advisory because they overlap, and some of them never really stop. But these are rough numbers here. Efforts were made around the country starting in the 1970s to pass legislation that would require that if you're going to teach evolution, you got to teach creation science along with it. So, what's creation science? I'm glad I'm talking to NCSE members because you are very familiar with this movement. Let me just say that it's an effort to take a biblical literalist interpretation of Genesis and claim scientific support for it. And it's the claiming of scientific support that gets you in trouble, because if they claim scientific support, then they claim it deserves a place in the classroom to balance evolution. Eventually, a Louisiana equal time law reached the Supreme Court, and equal time laws were declared unconstitutional in Edwards versus Aguillard. Don Aguillard, like Susan Epperson, is another high school biology teacher. So what do you do when the courts say you can't balance evolution by teaching creation science? Well, you invent another kind of creationism, intelligent design. This movement began in the late 80s and grew during the 90s and early 2000s. Now, intelligent design differs from classical creation science by largely ignoring the age of the earth and Noah's flood and other biblical literalist elements. And they focus on the design inference, a narrow point, the supposed inability of natural selection or any other natural cause to generate structural complexity, like the vertebrate eye or bacterial flagellum or other molecular structures. Now, since natural causes are allegedly inadequate, complex life must be the result of an intelligence who is unnamed. But the IDer is obviously God. In 2005, an intelligent design school board policy failed in Kitzmiller versus Dover, district court decision after a full trial. Hey, we got to have expert witnesses, even if Darrow didn't. You NCSE folks are probably quite aware of NCSE's role in supporting the parent and teacher plaintiffs opposing this measure. And once again, the focus of anti-evolutionism shifted. The demise of ID largely brought the demise of the balancing approach. This brings us to the third general period, blunting evolution. Here, the approach isn't to bring in an obviously religious idea, even if couched as science, like creation science or ID, but to try to convince students that evolution is somehow shaky science, as Bryan had argued during the Scopes trial. Evolution is merely a theory in the vernacular sense, rather than the scientific sense of being an inferential explanation. Under this approach, it's okay to teach evolution, but also teach the evidence against evolution, or teach the strengths and weaknesses of evolution. The unstated goal is to make students question evolution so they'll be more receptive to a creationist explanation. A component to the blunting approach is, ironically in the light of Scopes, contend that teachers and students have academic freedom to teach and learn the weaknesses of evolution. It's an academic freedom issue. Now, you occasionally found anti-evolutionists arguing for academic freedom to teach creationism or ID, but such arguments fell on deaf ears in the courts. The fact of the matter is that a K-12 teacher does not have academic freedom in the sense that a college instructor has academic freedom. Basically, the way education law works is that if you sign a contract with a district, you sign a contract to teach that district's curriculum. You can't freelance teaching anything you want. And there were several trials where teachers tried to do that and they were struck down. So academic freedom for teachers, although argued for by both ID and evidence against evolution proponents, has never gotten very far. But as you will see, it still crops up. The blunting strategy continues, but it has been recently joined by what you could call the backsliding approach, where the pro-evolution side seems to be losing ground. our side, or maybe in danger of losing ground. And it has to do with how the Supreme Court interprets the Establishment Clause of the First Amendment. Recall from your middle school history class that there are two clauses in the First Amendment involving religion: establishment and free exercise clauses. They used to mean that public institutions must be religiously neutral, but that has been changing over the last 20 or so years as the Supreme Court has become more conservative. To test whether a practice violates the Establishment Clause, courts have relied on a 1971 case, Lemon versus Kurtzman. There are three prongs or tests of Lemon. Does the law have the purpose or effect of promoting or denigrating religion? Does it cause undue entanglement between government and religion? And it's worked really well for creationism and evolution litigation. All of these cases here, after 1971, cite Lemon versus Kurtzman as precedent. So Lemon has been very important to keeping creationism out of our schools. But some members of the Supreme Court have vigorously attacked Lemon, and those of us concerned about the creation and evolution controversy have been obsessing over whether they would find a case to challenge it. And the answer is yes. It was the 2022 Supreme Court case of the praying football coach, Kennedy versus Bremerton. In the course of striking down the two lower courts' decisions, the Supreme struck down Lemon versus Kurtzman. So now there basically is no accepted jurisprudence for deciding Establishment Clause cases, except for some sort of vague, hand-wavy history and tradition, whatever that means. If you want to see how to peel paint off the wall, read Justice Sotomayor's dissent in Kennedy. It is quite extraordinary. Another possibility for our concern about backsliding is an even more recent legal decision, Mahmoud versus Taylor. In Mahmoud, this issue was whether parents with religious objections could opt out their elementary school children from being exposed to LGBTQ storybooks, and the Supreme Court said yes. It is yet unknown whether opting out for religious reasons will be or can be extended across the curriculum. But as Justice Sotomayor replied in her dissent, next to go could be teaching on evolution, the work of female scientist Marie Curie, or the history of vaccines. We'll find out whether opting out for religious reasons applies to academic subjects and for future litigation. Backsliding can be seen in legislation over the past few years. Fortunately, only the bold-faced bills passed, but some others got too close. Some of these bills call for blunting evolution as theory, not fact. Some flat out call for the teaching of creationism or ID, as in the bad old balancing days. The West Virginia bill, which did pass, is especially tricky and confusing. Although the intent of the bill as passed is to promote the teaching of intelligent design, it leans into the academic freedom trope. It prohibits shutting off discussion of, quote, scientific theories about evolution. And since they consider creationism and ID to be scientific theories, well, there you go. The Wisconsin law is a parental rights bill, which have popped up a lot lately. It presages Mahmoud by requiring parents to be informed, quote, when a controversial subject will be discussed so that they can opt out their kids if they have religious objections to the subject matter. Now, usually these bills refer to issues of race, gender, healthcare, or history, but why not evolution? And the Supremes have just okayed this sort of bill in Mahmoud. The good news is the Wisconsin bill was vetoed by the governor, who, by the way, is a former science teacher. Recall that Bryan made 3 arguments against the teaching of evolution. Each of these have recurred through the history of anti-evolutionism, and we can recognize them today. The supposed incompatibility of religion and evolution is, of course, a through line from banning, balancing, blunting, and backsliding. But so are the attacks on evolution as a science. NCSE and its allies constantly are helping teachers be more effective in presenting why it is that evolution is good science. The third position is Bryan's view is essential. It was both a populist and an anti-expert view that placed great faith in the wisdom of the common man. Today's version of this is on the wisdom of the parents to determine what their children should learn, although it is selective. How to handle this problem is an issue for another talk, but I and many of my betters have spoken and written a lot about the importance of recognizing that the solution to anti evolutionism and many other contentious issues won't be found solely through facts and reason. You can't just throw science at it. Facts and reasons are necessary, but not sufficient. The heart of opposition to evolution or vaccines or GMOs or Holocaust revisionism or other contentious issues is people's values, their ideologies, and their identification with their social groups, with their tribes. But as I say, that's a topic for another talk. This 1925 cartoon asks of Bryan, Darrow, and evolution, when shall we three meet again? I guess the answer is that when it comes to education, they never really parted company. I hope you agree that Scopes is a good story and there are worthwhile reasons to know more about it. Even just being a good story is a worthwhile reason. But there are lessons to be learned that are relevant to today's issues as well. And thank you so much for tuning in today to my talk. And please do support NCSE.
Jeannie, thank you. As always, it's riveting getting to hear from you on the history of these events, and we're so thrilled that you were able to join us for the first of our series on scopes. I know we have a few questions in the chat. So, the first question is, to what extent do local teachers provide sound instruction about evolution? And it further says how many ignore or downplay evolution because they don't want to cause trouble or downplay because they are creationists.
Those latter especially are difficult statistics to acquire. You know, it is still frowned upon legally to teach creationism in the classroom. There have been, legal decisions, and I think teachers are not really willing to do that loudly and publicly. But I think a much bigger problem, quite honestly, is teachers just skipping evolution. If they believe that evolution is going to be contentious in their community, and the community is the parents of the kids in that class. This is a very localized kind of thing. If they think that they're going to get pushback, they're just going to skip those chapters. We just didn't quite get around to them. We had to spend so much time on photosynthesis. There's some very good research that has been done by Amanda and Glenn Branch and their colleagues at NCSE in conjunction with scholars elsewhere, doing survey research on the beliefs and practices of teachers. And I'm going to refer anybody interested in this subject to the NCSE website, where you can find links to those articles. They are very worthwhile.
Thank you, Jeannie. Another question asks, the age of the Earth was briefly mentioned. How prevalent was young Earth creationism in those times, as it seems to have become more prevalent now than back then?
Yeah, young Earthism was largely a product of that George McReady Price chap that I mentioned as the founder of creation science. He specifically was the founder of young Earth creationism. And it was his contention that evolution was certainly not true, but he knew enough science, and he was actually a geologist, and he knew enough geology to know that if the world was old, if the planet was old, there's enough time for natural selection to do stuff. So clearly, if you have a young Earth, you really pound a stake into the heart of evolution, as it were. So he concocted a lot of uh, data and reasons why the Earth had to be young, which were taken up by later young Earth creationists such as Henry Morris, people at the Institute for Creation Research, Answers in Genesis, and so forth. Yes, it has become much more popular now than it was during Scopes' time.
Thank you. The next question is, what do we know about Butler, the Tennessee legislator after whom the Butler Act was named? Who or what inspired him to introduce the bill, and what kind of research did he do? What was the reaction to the trial?
I suspect he was inspired by William Jennings Bryan, who was lobbying legislators in Kentucky and in Tennessee to pass anti-evolution laws. This was quite a social movement of the time, and many people were swept up by the oratory skills of the great commoner. He was really, you know, could really bring down the house, so to speak. Apparently, he did not do any research. He just thought, sounds like a good idea. Let's do this. And he actually was sorry that the Scopes was convicted, but obviously he supported his bill. So yeah, it's Butler is not one of the more important people or really famous people in this whole story, although he's the one who wrote and submitted this particular bill, and his name is attached to it for better or for worse.
Absolutely. I know we had several other questions that were in the chat. Let's see. One more is that Darrow received criticism even from some who were pro-evolution for his fierce cross-examination of Bryan, saying it was unnecessarily aggressive in some respects. What's your view, Jeannie?
Hmm.
That's a good one.
Well, you live by the sword, you die by the sword. I mean, Bryan was not a shrinking violet himself. He certainly was quite capable of wielding the jawbone of an ass himself, and and he was able to take it. I don't really feel sorry for Bryan. He was a politician. He ran for president 3 times and was an active politician all of his life. He could take it. I really and frankly, the kind of biblical literalist views that Bryan held really, as I mentioned in the talk, really were not compatible with
Mhm.
modern science. And he tried to fudge and squirm and pretend that they were. And actually, again, people should not confuse Inherit the Wind, which has this very dramatic cross examination. It's a great play. Everybody should see it. It has this very great cross examination scene. Um, where basically the Bryan character, William Harrison Brady, kind of slinks off in ignominy. That really wasn't the case. I mean, Bryan got in some pretty good licks too, and the reaction to the great debate at Dayton really kind of depended on what tribe you belong to. Moderate religious people and secularists thought that Darrow had just really wiped the floor with Bryan, and Bryan was just embarrassing. Fundamentalists thought that Bryan had really held his own, except, of course, that little bit where he backslid himself on the age of the earth. That was a shock to his supporters, who assumed that, as somebody who supported the fundamentalist cause, he also would be a young earther. But he wasn't. He was much more moderate in his views, and that kind of shook some folks up.
Wow. And a last question before we close for the evening. Someone says, my grandchildren will be starting high school soon. How can their parents make sure the school they attend will teach evolution? Is there anywhere to get information on this?
Every school, it seems, I don't know of any that doesn't, has a back to school night. It would be a lovely thing to go to the back to school night, sit down with the science teachers. If you have an earth science course in your school, certainly the biology teachers, that's where evolution is most likely to be taught. And just say, Mrs. Brown, Freddie is so looking forward to being in your class this year. He just loves biology. It's such a wonderful field, and he's really interested in evolution. He's going to get that's in your textbook, isn't it? He's going to be taught evolution, isn't he? Because we'd really love to see him, learn more about this topic. Be really, really supportive,
Mhm.
right? Teachers have enough crap thrown at them, pardon the expression. They really don't need people coming and say, "You're going to teach evolution, right, Mrs. Brown?" They don't need that. They would much rather have people be supportive of them than have an people attacking them from both sides. So the teachers know what they should do. In most every state, with very few exceptions, evolution is part of your state science standards. It's not always done as fully or as in as developed as fashion as we would like it to be, but in pretty much every single state that I can think of, evolution is in the state science standards. And the vast majority of local school districts adopt the state science standards because it's so much cheaper than writing your own. You don't have money to do that yourself. You just adopt the state standards. And besides, most states have some carrot and stick things where they will tie your adoption of the state standards to getting some state resources. So there's a tendency to adopt the state standards. So the teachers know they should be teaching evolution. You can the person was asking, how do we, what resources can we go to your state Department of Education, look up science education standards, look up biology, look up earth science if they have them, and see where evolution occurs, and that will give you an idea. Some states have a remarkably detailed description of evolution. Hoorah! Uh, you can be pretty, if there's a lot of evolution in your state standards, you're very likely going to get evolution in the classroom. If it's wimpy, then support your local teacher. She or he is probably going to need it.
Mhm. Absolutely. And thank you so much, Jeannie, again for joining us tonight. Thank you to all of our supporters and lovers of science who joined us tonight for the first in this series of webinars. If you have a question that didn't get answered during the series, please feel free to email us at NCSE. We're always happy to help to answer questions and help build another generation of people to fight for the accurate and robust teaching of evolution across the United States. As a reminder, this is just one event in our year-long Scope Centennial celebration. So please make sure you check out the remaining two webinars in the series and take a moment to register for those at our website at ncse.ngo, searching for Scopes Centennial Celebration so that you don't miss them. If you do happen to miss them or want to revisit this talk or the others, a reminder that each of the three webinars will be available at that same page at a later time. We also have plans to send a copy of that video to all of those who are registered, so it's just another incentive for you to register if you plan on joining us. And as always, if you enjoyed this event, please help us offer more of them in the future. Our work to promote science literacy and challenge threats to science education is only possible because of people like you. We invite you to make a contribution today at our website at ncse.ngo//donate scopes 2025, and we'll make sure to share that information. And for those of you that already support the work that we do, thank you.